Okay. All right, looks like that is in place. We normally reserve 5 minutes of time on the clock for rebuttal. If you want something different, just let us know, and we'll set it for that. Is that appropriate? Okay. All right, very good. Okay, then we are ready to proceed with the appellant.
Good morning, Your Honors. May it please the Court. My name is Robert Harrington. I'm a lawyer with Robinson, Bradshaw, and Henson in Charlotte, and I represent defendant appellant Wilmington Health, PLLC, in this appeal. I will ask the Court, I know there has been a pending motion to dismiss the appeal. Would the Court like for us to address that, or will the Court handle that on the papers?
Well, I think you can just address that along with your argument. I'm assuming that's based upon the interlocutory nature?
That's correct, Your Honor.
Okay.
So I'll proceed.
So, yes, you can go ahead and address that.
I'm joined by Norman Click of the Walker, Allen, Grice, Amons, Foy, and Click Law Firm in Greensboro. Mr. Click serves as the defendant appellant's trial counsel and as co-counsel on this appeal. And for the Court's reference, I have signed, this morning I signed the principal and reply briefs to sign onto the record. Okay. As an alternative, as the Court's also aware, Mr. Click has filed on the appellant's behalf a application petition for discretionary writ just as an alternative given the interlocutory nature of the appeal. This appeal arises from a lawsuit in which the plaintiff alleges medical malpractice. The specific subject of this appeal, as the Court is aware, is an order entered by the Superior Court on July 14th, 2020, that specifically prohibits counsel from being physically present at any deposition subsequent to the entry of the order. These depositions may, and quite likely will, include those of parties, witnesses employed by a party, including Wilmington Health, my client, and experts retained to testify on behalf of both parties. The order states, and it is at page 70 of the record, that plaintiff's motion to require depositions be taken by telephonic or virtual means is granted, and all counsel shall appear at any and all depositions solely by video conferencing, and counsel shall not physically appear in the presence of witnesses. The witnesses shall also appear by remote video conferencing outside the physical presence of any party. This lawsuit was filed on April 29th of 2019. As the filings and the record reflects, it involves a claim that Wilmington Health, through its employees, failed to timely diagnose a skin cancer, and that delay in diagnosis and treatment allegedly significantly reduced the plaintiff's life expectancy. That's in the complaint in the record. As the record also reflects, the lawsuit involves complex medical principles, and it has and will involve complex expert testimony and witness testimony. As of the filing of the appeal, the notice of appeal, only 2 depositions had been taken. They were providers that were employed by our client, Wilmington Health. No other depositions had been taken as of the time of the notice of appeal. The Superior Court entered, just as background, a discovery order in January of 2020 prior to the order that's in dispute today. And that set a timeline for a trial in February of 2021, which, when we get back to the Superior Court will be revised because that time has passed. It permitted depositions to be taken by telephone or video conferencing, but it did not, that earlier order did not prohibit counsel from attending in person with their witnesses. The transcript reflects, and this gets to the motion to dismiss and the preservation issues, the transcript reflects that the counsel had discussion with the court regarding the appropriateness of video conferencing for all depositions. There was no, based on the transcript or the record, discussion with the court of the appropriateness of what the court subsequently ordered, which was that not only would there be video conferencing for all depositions, but that counsel and the counsel's witness, including the counsel's client witnesses, would not be able to be in the same room. And that is the sort of narrowness of the dispute that brings us here today.
Let me make sure I understand. the scope of the issue before us. Is your chief complaint that counsel cannot be with their client, or counsel cannot be physically present with the witness?
The chief complaint, Your Honor, is it's a bit of a variant of that. It's that counsel cannot be physically present with their witness who is a client or an expert that has been designated by that party. So in Mr. Click's case, to the extent there is a witness who is an employee or a witness of Wilmington Health, the defendant, or an expert who's been designated to testify on behalf of Wilmington Health, then our position is that the case law provides, the principles provide that Mr. Click and that witness should be able to appear together in the same room, physically present, notwithstanding the order.
How about opposing parties and opposing witnesses?
Our position would be that that is up to, so for what we've cited is case law that supports the notion in North Carolina and elsewhere that there is both a right under the rules and a right, or at least the rules do not provide otherwise, and a right under the essentially due process case law to attend physically present with your own witness, including an expert witness. We are not contesting the question of whether counsel should be able to be present in the taking of the deposition or opposition to a witness. Again, I think our position would be that that would be at counsel's discretion, but our issue here is that the court, in an order entered after the argument, specifically directed that counsel could not be present, including with counsel's own witness, who might well want counsel there for support, for guidance, for help in asserting a privilege. In many cases, witnesses simply want their counsel there so that they can feel more comfortable, express themselves more completely. And so that's the issue that's before us, and particularly for constitutional purposes. And I've intentionally put the constitutional issues second behind the issues of interpretation of Rule 30 and Rule 26, because I think that's probably where it belongs if we can avoid the constitutional issue. But the constitutional issue is the right of a client, the right of a party, the right of a witness to have their counsel present in any stage of a proceeding, a judicial proceeding, including a deposition.
Not just present, but physically present.
Physically present. And that's, just to fall back into just briefly on the interlocutory appeal issues, as the court is well aware, the standard for the general standard for interlocutory appeal is that the issue involved a substantial right of the appellant, and that the right would be lost in the absence of interlocutory review. Here, as in probably most of these cases, as Judge Stroud, as you anticipated, those issues dovetail. And so here, where the issue is the substantiality, the substantialness of the right, it goes both to the merits issue and also to the issue in terms of substantial right for purposes of appellate purposes. And the two North Carolina cases that we've cited, and we think from our research, these are the two North Carolina cases of this court that come closest to addressing the physical presence or the accompanying of a lawyer with his client witness, are the Henry Roberts case and the Tropic Leisure case, one from 2002 and one from the Tropic Leisure case from 2017. Both of those cases, we believe, stand for the proposition that a party, a client, is entitled to have his or her attorney present, and we would say, in this case, physically present, through stages of litigation. In the Roberts case, it was a appeal to a Board of Education from a long-term suspension. A student had been suspended for the remainder of the year. It had gone through the school. The law required that the student be given the right to an appeal to the local Board of Education. The Board of Education's policy prevented or prescribed a lawyer from being present with the student. And this court, after considering it and applying the principles that were set out by the U.S. Supreme Court in Matthews versus Eldridge, concluded that the student had a right to have the attorney, his attorney, her attorney, with him in that case, with him physically for that proceeding. The question wasn't whether he could get advice from the attorney or have the attorney essentially on standby, but whether the attorney could be or had the right to be, whether the client had the right to have the attorney present with him.
But that's when, that was a merits hearing, correct?
Yes, Your Honor.
Basically on whether or not the student would be allowed to return to school.
That's correct, Your Honor. And so it does not address the one-step remove issue in some ways that we have here, where it's a deposition. But as we've cited in the brief, a deposition in all of these cases is really perhaps not even one step away from trial, in the sense that Rule 32 allows the deposition to be used as substantive evidence at trial. And so you have, we would say, a similar, if not the same situation, where to the extent the client has a right, and we believe Roberts and Tropic Leisure stand for that general principle, has a right to have the physical presence of an attorney, it should apply in the deposition context too, because of the potential use of the deposition.
And looking back at things, obviously, we know a lot more now about the situation in COVID and remote proceedings than we knew back then. But as things continue, I guess it would be even more likely that depositions might be used at trial than maybe they would have been in the past if there are travel restrictions or other things in place when the trial actually happens.
I agree, Your Honor, and I think one of the challenges that we have here, and we concede this, we're all with the courts and with the members of the bar, we're walking through uncharted territory. And we are balancing, and one of the cases that we cited was from a federal district court judge in the Eastern District of Louisiana, Judge Fallon, in the Redmond case. And there the court, it's a relatively brief opinion, but the court balanced the interests and, determined that the attorney is unable to fulfill his or her duties to the client in the same way if he's unable or she's unable to be present with the client. And there are various, as I said at the beginning, there are various reasons for that. One is just the desire of clients, and we've all had them, who have engaged an attorney or had an attorney engaged for them, and who are, want the benefit of having that attorney with them. One of the issues in this, I've addressed, I think, at least indirectly, the substantiality of the interest for interlocutory appeal purposes. The second step there is that whether the right will be lost, if the decision is, or if the appeal is deferred until appeal from a final judgment. And here we think this is similar, and there are a few categories of cases where this court and the Supreme Court have held consistently that there is a right to interlocutory appeal because the right would be lost. One of those areas is privilege. An assertion of the privilege and a decision by the trial court that a matter is not privileged. And consistently the court has allowed appeal of that. I think in a couple of senses that provides guidance here. One is that the difficulty that a client or a witness may experience, or an expert witness may experience outside the presence of a witness, is something that would be very hard to measure or correct on a final appeal. But perhaps even more directly, one of the things that a lawyer attending or a client having a lawyer attend a deposition is keen to is the very protection of the privilege. And one of our concerns is that it is much more difficult to intervene to preserve a privilege where it's necessary from a remote. And all of us have spent the last year and a half now on, in remote proceedings and remote meetings, but it is harder to intervene in a way that clients and counsel are accustomed to assert and protect the privilege when you're not in the room there. That's just a harder process. And again, this gets back to, this is a question of the desire and the discretion of the client or the expert witness and his or her lawyer. It's not to require that the other side, the party taking the deposition or another party who in another case may be attending the deposition, is required to attend. It's a question of whether we would contend due process right of the client to have the attorney attend to defend that deposition should be vindicated.
Let me ask you this, is there a for lack of a better expression, a least restrictive means argument here. I mean, here we've got separations, we've got masks. If it's Judge Carmichael cited the pandemic as the basis for his order, correct?
Yes, Your Honor.
So are you arguing if the pandemic was the reason to put the remote video conferencing or remote in place, that prior to restricting a party or a party's witnesses from the council, if it was a spread that was, this was last July, this is not in 19.
Correct.
We knew a lot more then than we did the year before. But is there an argument here that if he wanted to put masks, if he wanted to put physical distancing, if he wanted to put some safeguards in there, that he was obligated to do that as opposed to a wholesale prohibition?
That's exactly right, Your Honor. I believe we've argued that, I think both in the principal brief and the reply brief, and the argument there being, playing it out, that's what other courts have done.
Right.
And it's, courts from different areas, but there are at least 2 federal courts that I think both in calendar year 2020, one from the district court in South Carolina and one from the Western District of North Carolina. The North Carolina case may have been, Judge Metcalf may have been had to have been 2020 because that was the pandemic. But in both of those cases, the courts considered the measures that have been put in place by counsel to protect and preserve the safety of the persons present, and determined that given the counterbalancing interest of physical presence at a deposition, those depositions should simply go forward in person with those protections. In other cases, courts have said, if one party doesn't want to be there, if one counsel doesn't want to be there, then we can arrange it so that the video will cover. I mean, one of the questions that's been raised by the appellee is whether, you can really see the inner workings between client and counsel or witness and counsel on video. And we've now all been in proceedings where you simply have the company set up 2 different cameras. I mean, there are ways to solve those problems. And Judge Tyson, we believe those are the kinds of less restrictive things than preventing a client from exercising, again, what we believe is a due process right to physical presence of attorney altogether. The other thing that arose in this case, and it's another measure, and we realize that with the ongoing with Delta and wherever we're going now with the pandemic, this becomes more difficult to predict, but there is a pending motion to extend the trial date, or there was a pending motion, there was a motion made to extend the trial date so that we could see where things developed and take depositions with additional guidance, and that was denied. And I would put that, Judge Tyson, in the category, again, of less restrictive alternatives. So I think there are at least 3 types of things that a trial court can do, the Superior Court could have done here, rather than simply bar all parties from having all witnesses from having their counsel there.
Were those arguments made before Judge Carmichael?
I don't think those arguments were made because I don't think, and I think the transcript reflects that, because again, part of our issue with, and appellee has raised the preservation issues, is that it did not become clear that that was what the court was going to, that wasn't what the court was asked to do in the motion. The motion simply went to having depositions by video conferencing. It didn't go to the question of whether counsel would be excluded from the physical presence of witness. So I don't believe the arguments were made, Your Honor, but it's because the issue simply didn't arise.
And that
No.
wasn't part of the motion.
Yeah, that reminds me of, as I recall, the motion was about 2 specific medical witnesses, one in Wake Forest, North Carolina, one in Chicago.
Yeah.
And I just, so this reminds me of a question that I had, since I think they were looking at July in Chicago, and actually, since I was supposed to go to Chicago last July, I know that you couldn't really do that thanks to the 2-week quarantine. I mean, unless you wanted to stay in Chicago in your room alone for 2 weeks, which probably most attorneys wouldn't want to do, to go there for a deposition. I just want to ask about, we know the COVID timeline well right now, but someone reading, our case would not, and I'll ask both sides this, do you have any objection to us taking judicial notice of dates of the official executive orders regarding COVID and executive orders from the governor, Cooper, emergency directives from Chief Justice Beasley or Newby, or the executive orders from Illinois or Chicago for purposes of setting out the timeline and circumstances in the case. I mean, those are all, like I said, we all know them and, because we experienced them. But would you have any problem?
No, Your Honor, we don't. I would point out that one of the, and I'm not sure how much time I have left. I do want to reserve the 5 minutes.
Okay. You're at 10:23 right now.
Okay.
You're at 10:23.
One of the other points we wanted to make, and this was before we get to the due process issues that we've actually jumped ahead and talked about some, is there, two other issues about the interpretation. The motion cites Rule 30B-7 and Rule 26C. And Your Honor's question, Judge Stroud, made me think of that point on 26C. One of the concerns that we do have, and one basis for our objection, is that there was, essentially oral presentation by counsel, and there were the issues that the court has asked about taking judicial notice of. But we argue and believe that the appellee, the plaintiff, in making the motion, failed to establish, and the district court, the trial court, failed to require the appellee, the plaintiff, to establish good cause. There was no, quite understandably, counsel talked about his concerns of having, himself be in the room with others during COVID, sort of general concern of having groups of people in a room, but it's not as if, for example, there was affidavit presentation of clients and their interests or other parties or persons to be protected pursuant to 26C. And so, again, recognizing that the trial court and counsel were struggling with a new situation and trying to make the best of it, that still doesn't allow us to get away from the requirement in 26C that there be some actual, we believe in this case, evidentiary showing of good cause. And we've cited, in at least one of our briefs, the Tennessee-Carolina transport case at 291, North Carolina 618. We've also cited a couple of places here, I think Gray Wilson's commentary in North Carolina civil procedure. And I'll just read quickly for the court. Mr. Wilson, in one of his sections, 2610, says, good cause for protective order must be supported by specific examples or reasons demonstrating the potential for significant harm to the movement. A party seeking a protective order may not rely on speculation about possible or conclusory statements to establish good cause. And so we've got a concern here before we get to, and without getting to the constitutional issue about whether Rule 26 was applied appropriately. And while I think we are on an abusive discretion standard, Judge Stroud, in one of your opinions, the Myers case, you mentioned and cited other cases for the proposition that an error of law, misapplication or misapprehension of law, is by its nature it fits within the abusive discretion standard. The other point, and I know I'm running short on time, that I wanted to make in the, prior to getting to the constitutional issues manner is, I think there is a question at least about the reach of 30B-7. With 30B-7 by its wording, and I checked last night just to make sure in the supplement that came out in the last couple of weeks, which addressed the West supplement, didn't address the rules themselves. It addressed the rules of practice and some other things. So as best I can tell, the current version of 30B-7 actually talks about either a stipulation or a court order for the taking of a deposition by telephonic means. There are two issues there. One that I'll mention, although it is not a bone of contention in the case, but it does arise from the rule, is unlike the federal rule, it actually doesn't talk about other remote means. The federal rule now, at least for the last couple of years, perhaps more, talks about telephone or other remote means. As much as we've all struggled with the pandemic and how to address it, 30B-7 at least deserves, the attention of whether a court can require. In this case, I think there actually would have been a stipulation probably as to video, and I don't want to assume that I wasn't there for the trial proceedings, but whether some type of video option would be available. But 30B7 is restrictive in its language, and as we talked about in the brief, to the extent it allows for, remote proceedings, it speaks in terms of taking, which, we realize that that's picking at language, but we believe it also supports our position that a party deciding to take a deposition can, be subject to an order or a stipulation to take the deposition by some type of remote, including telephonic means, but that doesn't negate the interest of the party essentially defending the deposition, defending the witness, and having the witness, if that is their choice, present. So we believe both on the interpretation of 30B7 and on the constitutional issues, there's a recognition of, at least implicit recognition of this interest and right of the witness being defendant, the party witness being defendant, to have counsel at their option present with them.
And I see you're right under 5 minutes, and I'm just noticed the little lights aren't on. Is that clock up there not working?
It is not on. I saw it on earlier.
Okay.
And I don't know if I did something to kill it, but it's not working right
I
now.
don't think there's anything you can do to kill it that I'm aware of, but anyway, okay. Well, thank you. I just noticed that the little
Do I have
light's not on.
a few minutes?
You're at 4:35, so,
Right.
yeah, I just wanted to let you know that you were,
Dylan?
You're in your rebuttal time, right?
just barely, yeah.
Yeah, 5 minutes.
Thanks.
If you can fix it, sure, yeah.
It's 4:30, you got 4 minutes and 35
Yeah.
seconds left on your rebuttal.
Thank you, Your Honor.
Yeah, I'm sorry, I didn't notice that the little light was not lit, and,
Yours is out too, Donna.
no, well, mine is out right, the time is on it, and the light's out right now because it's not running. Oh, well, there you go. Plug in.
This one is still down.
Oh, no, it's still down, okay. Huh. Weird. I still miss our old ones. I don't like
It was
the new
working
ones.
earlier, so
It was,
it may just be a
yeah, it was.
bulb.
See, our old ones didn't do this. And I could control the old one up here.
I use the grandfather clock.
I can't see the grandfather clock. Well, there's so many layers of plexiglass reflection between me and the clock. I actually can see that far, but it's hard with this. Okay, that's okay. If it's not going to behave today, I'll just,
Just give them a warning.
It looks like it's decided to take the day off, Your Honor.
okay, all right. Well, I'll try to pay closer attention to the clock since you don't have one. All right. Mine's working. Mhm. Yeah.
May it please the court, Kyle Nutt of Reese and Nutt on behalf of the plaintiff appellee Susan Hall. My client, Ms. Hall, was a patient of Wilmington Health. In 2018, she went in for a diagnostic on a lesion on her neck. That lesion was removed. However, Wilmington Health never did anything with it. They never tested it, despite lots of complaints that would lead even a layperson to suspect cancer, including a history of skin cancer. When she returned to Wilmington Health when the issue reappeared, it was diagnosed as invasive malignant melanoma. And so this lawsuit arises from the failure to diagnose that, which has, according to her doctors, given her less than a 20% chance to survive beyond 5 years. Before the court today is indisputably an interlocutory appeal. The appeal should be dismissed because there is no substantial right implicated by the order appealed from. The order requires that depositions be taken remotely with both audio and visual interaction for all parties. The authority to make such an order is expressly conferred by the legislature of this state upon the trial court through the North Carolina Rules of Civil Procedure. Rule 26C affords the trial court broad discretion in setting limits and conditions upon discovery, including, quote, that the discovery only be had on specified terms and conditions, including a designation of time and place, quote, that the discovery may be had only by a method of discovery other than that selected by the party seeking discovery, and, quote, that the discovery be conducted with no one present except persons designated by the court. Rule 30b-7 likewise contains broad discretionary authority to the trial court to make such an order. Quote, "The parties may stipulate in writing, or the court may upon motion order that a deposition be taken by telephone." And as to the argument as the difference with the federal court rule, I would argue a telephone is a telephone. Whether it affords video or not, it's still telephonic electronic communication.
Mr. Nutt, let me ask. It appears to me that what the judge's order gave the plaintiffs kind of a lot more than they asked for. The motion was just addressing these two doctors, one in Chicago, one in Wake Forest, and then the order actually extended to all depositions, presumably until further order. I suppose, if somebody went back to court and asked for something to be changed, perhaps it could be. And also, it appears to me that the motion did not ask for every person to be basically in a separate location, including an attorney and their own client. Is that accurate?
Respectfully, I would not agree with that, Your Honor. I think our
Okay.
order was, or our motion was very broad in
Okay.
what it requested. It requested, quote, "An order requiring that depositions in this matter be taken by telephonic or virtual means without any limitation."
Right, but as far as so taking it by, and I'm just trying to understand the scope of it, by telephonic or remote means, so obviously, you weren't asking for a witness to not have someone present with them in the room. If the witness said, "Hey, I want my attorney here, I need help operating the computer," whatever reason, were you actually asking for them not to have a person there with them?
Well, to be clear, Your Honor, there was no contemplated further deposition of the defendant's clients or witnesses.
Okay, but I mean,
that were employed.
regardless of who it was, I understand, but were you asking for every person to basically, and I was sort of thinking about how this would work and be in compliance with the order, as far as, COVID and whatever, obviously the defendant's attorney could consult with the client right before the deposition in the next room.
Sure.
Could remotely attend in the next room and have this person in that room.
And that's precisely.
They could all drive to the deposition together. I mean, what is the point in saying they can't be together during the deposition is my question.
I think that is how it's been done in every deposition I've done in every single case since the pandemic, except this one, where this was brought up as an issue.
Everybody in a separate spot.
Yes, Your Honor.
Is that by order, or is that just by the people said, "Hey, I'd rather do it from here"?
We've done it both ways. We've done it by just consent of the parties. We've done it by orders of the court.
Right.
And I think the practical reason is the technology works better if you don't have two people with two separate microphones in one room, because what we started experiencing early on was feedback loops, where you've got two mics and they start feeding off of each other, and so there had been a lot of difficulty with that. I agree with Your Honor, and I don't think the order extended to limit presence in the same building. I don't think that that's a fair reading of Judge Carmichael's order. What he was saying was witness in one room with a terminal, counsel in another room with a terminal close by. There's obviously situations where we've had counsel come in during a break and maybe pull up a document or something like that. Those aren't the type of issues we're concerned about. The real issue was people being physically in proximity for extended periods of time in a closed space.
But why does a discovery order need to address that? If the two people want to be in physical proximity in a space, I mean, that's sort of a separate issue, and we're dealing with discovery.
What we were dealing with at that time was the counsel wanting to go in person to take our experts' depositions, who are medical professionals, that's a very sensitive issue, who are prohibited from traveling.
Sure.
Our client, who is at risk, and a host of other treating physicians
Right.
that had seen her. So that was the contemplated issues before us. And of course, being in close proximity, you're either going to have a mask on during the deposition, which I would argue is far more inhibiting on your ability to observe and make impressions about a witness than virtual. So those were the backdrop of what was being considered. I don't think there was any argument made by the defendant to say, wait a minute, Judge, what if I want to be with my experts, or what if I want to be with my client? Those issues were never raised, and I would argue that those
An opposing counsel is saying the reason they were not raised is because they were not requested in the motion.
Well, again, the motion was very broad. It said all depositions. And if you read what they put in their response brief, they understood it that way, Your Honor. They specifically said at page 49 of the Record on Appeal, paragraph 7 in their response, quote, nonetheless, plaintiff now seeks to deprive defendant's counsel of the right to take any in-person depositions. So they certainly understood that the scope of this was extremely broad and applied to any depositions in the case.
Well, that could also be read to say that the request would prohibit them from being physically present with your client or your client's witnesses. This is not an admission or stipulation that would prohibit them from being with their clients or their witnesses.
I would disagree, Your Honor. I think that they knew it was very broad, but more importantly, they admitted at the hearing. They asked the court, you can look at the trial transcript. They asked the court during the hearing if the order about audiovisual depositions only, quote, goes both ways. And the court said, yes, of course. They didn't say, oh, wait, Judge, we need to be with our client. We've got concerns about that. They moved on to another topic and started arguing another issue.
Well, goes both ways means they could not be physically present with your client or your witnesses, or you could not be physically present with their client or their witnesses. That's the way I interpret goes both ways. That's not a stipulation. They cannot be with their own client.
It may not be a stipulation, but they had every opportunity to argue those issues. They were on notice that this was a very broad request. This hearing afforded them every opportunity to raise the concerns that they have now, and the fact that they didn't is no one's fault but their own.
Well, you clearly, in your motion on page 45, you reference specific individuals who in Chicago and in Wake Forest that was not subject to being able to travel or were under some restrictions, right?
That's correct. Those were the two that were presently pending, which gave rise to the overall issues we were concerned about for all depositions. Because if you read the motion, it says, for the benefit of parties, for counsel, and for witnesses. It did not limit it to just those two individuals. It asked that all depositions in the matter be conducted remotely.
Again, show me in your motion where you were seeking to restrict them from being present with their parties or their witnesses.
That express wording is not in there. What it says is that all depositions be conducted remotely. They understood it applied to all depositions. They
Okay,
understood
but
it
it's
went
a
both
different
ways.
issue on whether it's remote or not and whether they can be physically present with their client or their witnesses. That's two different issues, right?
I would argue that it's the definition of remote is physical separation. I mean, that is the whole point. That's how they're all done. I have not had a deposition yet where someone has argued this physical presence right other than this case. This seems to be generally accepted that when we're doing remote depositions, counsel is not seated beside their client in the room in the midst of a pandemic where the concern is exposure to people.
How do you address the, for lack of a better term, least restrictive means that they were given a due process right to counsel? That if there is a safety concern, there's other than an explicit prohibition, that there were means that they could have taken that were least restrictive.
So I would first argue there is no due process right to physical presence of counsel. No case has ever held that. Second, if the court were inclined to explore that avenue, I would argue that whether or not there is a least restrictive means is getting into an issue of the court's discretion of the best way to handle this. This is an abuse of discretion standard on these issues. And so what this court, what your honors may believe was the best way of doing this, may not be what Judge Carmichael thought was the best way of doing this. But the question is, was his decision so manifestly unreasonable that it couldn't have possibly been the product of a reasoned decision? While you may agree with his decision, that doesn't make it abuse of discretion, and that would be my argument, that that was within the trial court's discretion.
But if we would find there is a constitutional right to presence of counsel, then that standard would not apply. Do you agree with that?
If you were to find that there is a unarticulated constitutional right to physical presence of counsel at a discovery deposition that could not in any way be set aside by the trial court under any circumstances, then I would concede there's no point in arguing anything else.
I don't necessarily agree that it would have to be that absolute.
Well, if it's not absolute, then I would argue it's back to the court's discretion.
Well, no, in terms of your assertion that the terms would have to be that absolute in order for the constitutional right to apply. That's what I'm referring to. So if it is a constitutional right to counsel, and that means meaningful access to counsel as well, do you at least agree that?
I would agree that meaningful access to counsel is a right that litigants are afforded, and I think that the remote means absolutely afford that. That's why it's provided for in our rules. I can quote.
How many times you've been in depositions where either bandwidth or technological problems where parties were dropped?
Sporadically, but I've also been in numerous depositions in person where a court reporter's machine shuts down, or where someone has to go to the bathroom, or there's some other issue. You know, someone has a panic attack. All these things happen.
Right.
I've been in personal depositions where the physical presence of an attorney barking at a witness has caused them to shut down and take a break and shut the whole thing down while they compose themselves, or to become crying and inconsolable for a period of time. So these things happen no matter which mode you choose. I think what we all have to accept is this is the 21st century. If we take a recess, they can pick up the phone and call their counsel. It's what we do in all of these depositions. Again, this is not novel. It has not been since March of last year. This is what attorneys have been doing to work through a very new situation. We've been working through these issues collectively. When we need guidance from the court, we go to the court. But none of this rises to the level that they argue that these people are somehow being deprived of counsel. And for goodness sake, this isn't about their clients. That's already happened. There is nothing in this record to show that we're out there trying to take their clients' depositions and exclude them from that. This court's order specifically said, if you have an issue you want to bring back before us, any judge in New Hanover County can modify this order, or the parties can, by written consent, agree. So I'm here to tell your honors, had they stood up, had we gotten into the speculative realm where I said, you know what, I've already deposed the only 2 treating physicians that ever touched my client, but now I'd like to take them again, or I'd like to take a 30B6 deposition. They could say, hey, Mr. Nutt, we didn't contemplate that when this order was entered. We'd like to be there physically present. I can consent to that to avoid this entire thing that we're going through now that has derailed this case by over a year. Or if I don't, they can go to the New Hanover County Superior Court on 5 days' notice, ask for a modification, and I'm willing to bet any judge in New Hanover County, any Superior Court judge, would have granted them that opportunity. That's not right. It's not an issue before this court. It is a red herring being used to make you feel like they're being deprived of something that is not happening. This is a phantom. It's a paper tiger. Boo. They're hoping that you jump on it. It's not an issue. What's issue is taking our experts' depositions, taking my client's deposition, and treating physicians. I have no intent. I did not notice any depositions of their employees. They have never designated expert witnesses despite missing their deadline. So those aren't issues presently before this court that you need to bend over backwards to find some constitutional right that I would argue doesn't exist, has never been recognized before, just to pull this out of the ditch for them.
Let me ask a few questions. And I was in banking, so I didn't do litigation. So some of this may seem like Deposition 101. First question, the person defending the deposition can ask questions. Is that correct?
On cross-exam, yes, Your Honor.
They can.
Mode of trial.
So that there might be some feeling that there's a disadvantage if one lawyer can be there and the other one cannot be there, I guess, potentially.
If someone is physically present and another lawyer is not physically present, I do think that creates an unlevel playing field.
Question two, some of these people are employees, they're not, who has the constitutional right? Is it the defendant that has the constitutional right, or is it the witness that has the constitutional right to have a lawyer present?
I would argue only a litigant has a constitutional right to assistance of counsel. I would argue no one has a constitutional right to the physical presence of counsel, because no court in the history of this country has ever held that.
So if I'm deposed in a case and I have nothing to do with it, can I have my lawyer present? If you two depose me because I happen to be standing outside and watch the whole thing, do I have a constitutional right? Do I have the right to do it, to be present?
I think, I haven't researched that issue, but my recollection is any witness may have assistance of counsel to protect themselves.
And I don't think the order covers that, because it just says that the party's counsel cannot be present. So that's all it says.
But physical presence is different from assistance of.
Yeah, but I don't think this order would prevent me from having my lawyer present, because the order only restricts to have, it says
Well,
that
it
any
says
witness,
no counsel shall be physically
the
present.
counsel be either party. I thought no party.
Presumably would cover even, let's say, a witness who, for whatever reason, said, gosh, I think I need to hire my own attorney for this.
I think
which
the
happens.
order says the counsels.
And the way that's been handled is, again, we have had other cases where that is an issue, where a witness shows up with an attorney. And that's never been anything anyone has objected to, but they have attended remotely just as all the other attorneys
And this
have.
last question, so when they represent the defendant, Wilmington Health PLLC, do they also represent their employees when they're being deposed?
I believe it depends on a case-by-case basis. The law is pretty clear that the attorney-client privilege does not extend to non-controlling employees, somebody outside of like a management structure. So I think that would depend. In other words, a line-level employee, I don't think they have any privilege or the same rights.
So they don't represent these witnesses in any regard, is what you're saying?
I believe they represent the individuals that were the managers, one of whom was the licensed physician who we testified, who we deposed.
Okay, but not the other witness, per se. So, because I'm just trying to figure out whose privilege is it? If they don't represent that person, then why should they be, I mean, I guess you would be arguing, why should they be allowed to be there with somebody they don't represent, and you're not allowed to be there with somebody that...
That's fair, yes, Your Honor.
Okay.
But again, those issues were never brought up in this case. That's never been anything that's actually right.
I'm trying to get to the constitutionality of it, like, who's got the due process right, and
If I understand their argument correctly, I think they're arguing that the defendant itself has a due process right to have their counsel present at depositions of the corporate representative if those were to happen going forward. If we did a 30B6 deposition where the corporation designates a witness. But again, that never happened. We had deposed both of the physicians prior to the pandemic. They were physically present, defended those depositions.
do you think they have a constitution, would you concede they have a constitutional right to be there for those 30B6 depositions if it's the corporate representative?
Not physically. I don't think there's any articulation of, what is physical presence? Are they there to give a hug or to hold hands, or are they there to be a lawyer and provide guidance, to cross-examine, to make objections? If it is to be a lawyer, all of the lawyer's duties can be effectively conducted remotely.
Well, I mean, and I think that might depend on the technological savvy of the witness also, right? I mean, I'm just thinking if you were deposing my mother, you'd better darn well be sitting right there next to her, okay? You know, I realize these witnesses are probably very good with computers, but, I mean, that's going to vary.
Your Honor, I'm glad you brought that up. I can speak directly to that. We have had cases where there were very technologically unsophisticated witnesses. For instance, somebody who nails in windows, big construction defect case. That individual goes into a place where they sit down in an office, set up, with their counsel in the same building. It's a Zoom platform. They literally do nothing. They have to touch nothing to make it run smoothly. Anytime there ever is an issue like, hey, we need to mute your microphone while we take this recess, an assistant or someone comes in and mutes the microphone for them. And that's the extent of any technological interaction the witness actually has to do. The technology is so easy for us as lawyers to use that it literally allows us to just, like an Elmo in a trial, we can take an exhibit up for the witnesses. It takes over their screen and we show them, look at this exhibit, look at this line, read this. We can circle things and point them to it. It's very intuitive. It's very user-friendly for the witness. I think Judge Carmichael indicated he was familiar with those things and said it had run smoothly in his experience. My experience has been the same. I would argue to this court, as somebody who's been litigating and taking depositions for now over a decade, remote depositions are better than in-person depositions because you have access to your complete file digitally. You can show the witness exactly what you want to show them. You can highlight it. There's no hemming and hawing while they read through a 30-page document. You get right to the point. It's far easier and more efficient, and what we're seeing, even when the virus has been in periods of abatement, is a lot of attorneys still saying, let's just use the remote depositions. There's no
Well,
travel.
there's definitely advantages and disadvantages, I guess, as back in the olden days when I was taking depositions. Sometimes you learn things from being in person, like, that is a strong odor of alcohol from that witness. I might need to do some research on that background. But anyway, I guess those things are lost in the remote world.
Well, and, we've resumed oral arguments here today. Y'all are physically present. We've got safeguards here. And I will tell you, compared to WebEx oral arguments, there's no comparison in terms of technology, bandwidth, fading out, can't hear people. I mean, the interaction that you have from being live can never really be duplicated through video. I'm sorry. There's going to be lags. There's going to be, so it's just not the same. It's not the same.
And it may not be. I definitely understand Your Honor's viewpoint on that. What I would say is that does not create a constitutional right to physical presence, given what the rules expressly state. They are reading something into the rules that is not there.
Let me ask you a question. So the judge has discretion, and I would assume it'd be an abuse of discretion if the judge sets some parameter where there's no reason or there's no, so articulate to me why it is important that they not be present with their witnesses. Does that create some, what's the reason behind it? It's got to be, it can't just be based on no reason.
Well, I think in that circumstance, it was the health and safety of everyone involved.
If the witness was like, I'm okay with this person sitting next to me, I'm fine with it. If they social distance and follow, I'm okay with them being there. Is there a reason why or is that just enough? Is that enough? Would that be an abuse of discretion if the?
I think if that issue was brought to the court's attention, which it never was, and was presented that, hey, everyone that wants to be in that room together consents to it, and it's not going to prejudice, that the technology is going to work fine, then there would be no reason to prevent it. But that issue was never brought to the trial court's attention. And even if they didn't have notice of that potential issue, which, again, I disagree with, even if they didn't, when that issue arose, if it arose, which is pure speculation, they had an opportunity under this order to go back to the trial court and say, hey, Judge, time out. We want to be there in person. And the court could have absolutely granted that request. I could have consented to that request.
Right, and, we realize, obviously, this is something you could go back to and revisit, but again, do we want the parties to incur the cost of, and time and delay and all that, and the court to have to deal with, people coming back, saying, oh, for this deposition, we need to do this, and for this deposition, we need to do that, so.
The time and delay that this appeal has affected on this case
Right.
exponentially outweighs a 5-day notice to go down to Superior Court in New Hanover County and say, hey, Judge, we consent to this. Or just asking me an email, Mr. Nutt, would you agree for us to be there with our client? Sure. Over. That's it. So I would argue that the way they have prosecuted this appeal has consumed unnecessarily judicial resources. It has had the sole unequivocal benefit to them of getting a continuance of a trial that was denied by the Superior Court. And for the life of me, for all the research I've done, I cannot find a single case in United States history that has ever articulated a constitutional right to the physical presence of counsel. I'm not a criminal
and
lawyer.
If I could just say, I think, we've never had a situation like the last year and a half.
But
Or,
we,
even when we think about all those issues, we never even thought about, would someone be physically present? It would be a very unusual situation where there's a telephone deposition or whatever, based on travel. We've never had a pandemic like this that affects.
I would agree with that, but I would also state that the legislature crafted rules long before the pandemic that afforded these powers to the trial court, and they were not limited. And the question before this court is, number one, is this even right? The answer is no. Number two is it an abuse of discretion? And the answer to that is no. Judge Carmichael had a reasoned decision. The issues that they complain of now were never raised before him. And not only did they have an opportunity to do it at the hearing, they had an opportunity to bring it up later if it became ripe.
And let me ask you too the same question I asked them about, like I said, we know the COVID timeline very well and the orders and whatever, but would you have any objection to the court taking judicial notice of the official executive orders in either North Carolina or perhaps Illinois or Chicago, just for purposes of setting out a timeline as to events?
No objection to that at all, Your Honor.
Okay.
Do I have any time remaining?
You have 1 minute and 48 seconds.
Okay, then the final thing I would just like to address is the sanctions that we requested in our motion to dismiss. Nothing about the order Judge Carmichael entered deprived the defendant of any substantial right. This is a patently interlocutory appeal. There's no authority whatsoever to articulate this constitutional right that they want Your Honors to manufacture. They now want the Court of Appeals to draft a new constitutional right that has never heretofore been recognized by the legislature, by the Supreme Court of this state, or any other binding authority. What they have used to manufacture this right, because they know that's the only way they can prosecute an interlocutory appeal and get the continuance of the trial that they weren't given, was to rely on discretionary rulings from other jurisdictions that are not only non-binding, they acknowledge on their face they're discretionary. The Purdue Pharma case specifically said that that court reserved the right to revisit the ruling and limit in-person depositions if it became a barrier to scheduling. So even the cases they rely upon do not support, don't even come close to supporting some constitutional right. Without that, this was an interlocutory appeal without any basis. It deprived my client, who may not get to see the light of day in a courtroom as she breathes because of the delay occasioned by this case. Justice delayed may absolutely be justice denied for her in her lifetime. That cannot go without consequence. This is not trivial. This is important. This is someone's life. It is their right to be judged by a jury of their peers, and she should have been afforded that opportunity, not based on some unsupported argument of a constitutional right that does not exist, has never been articulated, synthesized by cases that have nothing to do with civil law. Miranda v. Arizona, Gideon v. Wainwright, these are cases about criminal defendants which the courts of this state, both this court and the Supreme Court, have articulated have no bearing on civil cases. And yet they
And
argue.
your time's up, so if you want to just conclude. Yeah.
I appreciate it.
Okay, thank you. All right, and rebuttal? You have 4:35 since your clock is not working.
Try to be even briefer. Just a couple of points. First, as far as employees still to be taken, at least potentially, in the principal brief, the appellant referenced the fact that appellant has identified over 10 employees with knowledge of interactions with the appellee, the possibility, if not likelihood, of additional employee witnesses, and the 2 employees who were taken were both represented on the record by Mr. Flick as counsel. On the issue of there are benefits of electronic, certainly of technology, but virtually all of the things that counsel talked about being able to do remote, counsel can do in person with manipulation, use of documents, presentation of documents. Those things can be done during a deposition, in person. And since we're talking about defending the deposition, in the main, that's not something that attorney would be doing. On this continuing refrain that there is no constitutional right to the physical presence of an attorney, That's simply, rebutted by the Henry Roberts case and the Tropic Leisure case. They're not deposition cases. And Judge Stroud, as you referenced, we're in a new day. I mean, we are seeing these things arise in different aspects of trial practice. But as far as the recognition by this Court of Appeals that there is a constitutional right in certain circumstances in the adversary process to have physical presence of counsel, that is the essence of Roberts and Tropic Leisure, both of which relied on the U.S. Supreme Court's opinion in Matthews versus Eldridge. Those are the key points that I wanted to make.
Let me ask you a question about the substantial right, because it seems like it's got to be a substantial right that would be lost if you didn't get the appeal. This order does not direct anything about any particular witness. It's just a blanket order that says it can be modified. How would you answer an argument that this one doesn't affect a substantial right that could be lost, but if you had a particular witness, and then, because it does say it can be modified, and that judge denied it, that would be the order you could appeal?
Well, Your Honor, I don't think that...
Why does this one affect the substantial right that can be
Because
lost?
I think the wording of this order, as with any interlocutory order, can be modified, right? I mean, an order can be changed by the Superior Court judge who issued it at some point in the future. But this order is the governing order in the case. And our method for relief was to seek appellate, interlocutory appellate relief from that decision. So I think the substantial right we've identified, and I've just taken the court back to Roberts and Tropic Leisure, and the fact that it would be lost, I mean, what we are relying on is the theoretical, speculative possibility that there would be another motion made or a motion made to modify that counsel who has opposed this appeal and who has, was there for purposes of the argument and the order and argued for relief now says, if asked in the future, I might concede or stipulate that certain witnesses may be able to have their attorney there. We think that the importance of this constitutional right, recognized at least indirectly in similar contexts by this court, is such that the Court of Appeals should intervene here and give instructions to the trial court and to other trial courts about the parameters under North Carolina law of the right of a witness or a client witness or an expert witness to be accompanied at their consent, at their request by counsel.
Any other questions?
That's it.
Okay.
Thank you.
You have 40 seconds left if you want to use
Well,
them.
I would just wrap up by saying I think Judge Tyson said it perhaps more succinctly than we've said it so far. In a sense, this is a lesser, Judge Tyson, I'm blanking on the words, but a lesser remedy. What we are saying is that there were ways without directly impinging on the
Less
statute.
restrictive means.
Exactly. And that could have included, delay. It could have included what we've asked for here, which is just allow the parties, the entities, the persons who want to be together and who are saying, we'll take whatever risk there is because of the importance of the right to have representation of counsel physically, allow that to go on. Or, as the two federal district courts that we've talked about have done, the other option was to say, as here today, take the proper restrictions, use masks if necessary, and hold the deposition going forward as we are here today. So, thank you, Your Honors.
All right.
Thank you.
Thank you very much for your arguments. And we can adjourn.
All rise. This session of the North Carolina Court of Appeals is adjourned.
Thank you for your arguments. Appreciate it.
Thank you, Your Honor.